come to, as Norwegian, of course, Snorri Sturlason is to me well known. His Kongesagar is, or at least was, one of the most widely read books in Norway. When my grandfather grew up in a small farm in the middle of Norway, the two or the three books they had in the house was the Bible, of course, and the book of Psalms to sing, and it was Snorri's Kongesagar. So this was the book that was in every farm out in Norway at that time. Unfortunately, I don't think it is as widely read today among young people. Now they watch the Vikings on the TV instead, but I think reading Snorri is a more pleasing experience. I am going to talk today about the rule of law. So I know that you are addressing the question of democracy and the democratic basis of the rule of law. But I will then look at the rule of law side and say something about that. This brings out of my own research for the past several years. I've been researching the relationship between the courts, the judges, and the state power, particularly the executive, but also the legislative power, in situations where democracy and rule of law break down. And of course, we belong to rule of law societies with long traditions of the law, as you've already been talking about, the legal codes from the 13th century are a part of our cultural heritage and a part of our national self-understanding. But what I would like to do is to investigate a little further into the rule of law and warn about some of the weaknesses and possible deficiencies there, so that we don't believe that only because we have the rule of law and it has a democratic basis that we are immune against turning or society turning into more authoritarian situations. So I've called this authority, habitus and doxa, what threatens the rule of law society. And I'm going to talk about not that much rule of law as such, but of some presuppositions and pillars that the rule of law rests upon in our society. But let's just start with a very short and small introduction of what I mean by the rule of law and the Western legal tradition. And as I said, this is the Magna Carta. I don't think we have the same type of moment in our Nordic histories. I haven't seen that, but it may be that I'm not a medieval historian, but I haven't seen sort of the same type of binding of the king in the Nordic codes as we have in some of the European moments, like, for example, the Magna Carta or the Golden Bull in Hungary and other places. But it would be interesting for me if some of you have can correct me on this, because I would very much also like to place this more specifically in Nordic in the Nordic tradition. But the Western legal tradition and the rule of law, as we see it even today, has several components. One, of course, is the important thing that society is ruled by law, and this we certainly have also in the Nordic tradition. Med lov skal land bygges. It's in Norwegian. I can't say it in Icelandic, but I know it's something. Yeah. So this is important, but also that the emperor is bound by law. So law applies equally to all, even the emperor or the king. And that authorities must respect each other's rights. This goes back to the conflict between the emperor of the German Romanic Reich, Deutsch-Römische Reich, and the Pope on the investing on bishops, as you know, where one divided the competences and also subjected the emperor to a higher law, a division of power. So this is sort of the foundations of the rule of law, and which we know as division of power between the judicial, legislative, and executive powers as we know today. So this is the important part of the rule of law. Now, we can apply an institutional approach to investigate further into the preconditions and the functioning of the rule of law. I've been much inspired by an economic historian, Nobel Prize winner Douglas C. North, who has tried to explain the success of the West by going into the institutions and the building of the institutions back also to the Middle Ages. And he defines institutions as humanly created restraints that form social, economic, and political interaction. And he says precisely that the binding of power that happened in the Middle Ages and developed in Europe is one of his key explanations for the economic development and the success of the West through the Enlightenment period and through colonialism, and as you all know. And institutions then are composed of norms, not only legal norms, also social norms, that form incentives for action and that give resources for action. But also the norms and the institutions contain hidden knowledge and patterns, how to do things, the way to behave, the way to shape society, the way to deal with problems. And in institutions are also the shared assumptions that we all have, or what others have called the doxa, you know, the word orthodoxy, and the doxa is then what is not orthodox, what is not regarded as sanctioned by any authority, but just what we share of assumptions that we don't talk about, but we all know. And then also the state of mind of actors, what is taken for granted as part of our roles, what the French sociologist Pierre Bourdieu calls habitus, which then shapes our way of thinking. And the rule of law depends not only on the formal norms, but to a very large extent also on these shared assumptions, the tacit assumptions, the tacit knowledge, shared values, and the state of mind that we have. So that can be seen sort of as the part of the iceberg of the rule of law which lies beyond the sea level. Now, the habitus is very interesting because we have certain states of mind that are closely related to different legal positions. For example, the position of a judge, that a judge should be independent, should apply the law objectively, and so on. And we can see then that even if we have this self-understanding of the rule of law, we're not protected. One example, which is quite recent from Norway, is, I don't know if you're familiar with the social security scandal that we had, that was revealed some years ago. It appeared that our welfare authorities had been depriving citizens of welfare benefits, unemployment and sickness benefits, because they had stayed abroad without prior permission from the welfare authority. Now, according to the EEA rules and the internal market rules, there is free movement of persons, of course. So preventing people or depriving people of rights because they cross a border within the EEA is as such contrary to free movement, and is difficult to reconcile, and the EEA is, as it is in Iceland, of course, is implemented into Norwegian law with precedence over other legislation. So even if our social welfare law states that you lose benefits if you go abroad, this law, being contrary to the free movement of the EEA agreement, is not valid Norwegian law. So they were applying then invalid Norwegian law to the disadvantage of citizens for years, even from the entrance into force of the EEA agreement until this was revealed then in 2018. So it was thousands of people who had been affected. And even this was a criminal offence. If you did this, it was seen as social or welfare fraud. Many people were charged for the courts, and about 50-60 people served prison sentence for breaking a law that was an invalid law, which is, of course, a major rule of law scandal. And even I think the worst thing maybe was even that when it was revealed by the welfare authority that they had been in this way breaking the law, it took several months before they notified the police and the prosecutors. So the prosecution of people continued for several months, even though the welfare authorities were knowledgeable now about the invalidity of this. And how could this happen? This happened in a basically rule of law society like Norway, and it happened because the authorities applied the law, but because I think the EEA agreement has been a greater stress moment on the Norwegian legislation that we have been aware of. This shouldn't have happened because free movement is such a fundamental principle, such a fundamental rule in the EEA, that everyone should have reacted to it. But then no one did, from the lawyers in the welfare agency, through the police, through the prosecutors, and even all the way up to the Supreme Court. That a couple of these cases also went to the Supreme Court without being overturned. So this is an example that it's not enough to have, so to say, the self-understanding of having a rule of law, and even not enough to have the formal norms in place. It requires more. What we see then is that I don't have the figures for Iceland, but I expect they're not very different from Norway or Denmark here. Is that in our country, the rule of law is a system that is very much based on trust. We have less formal mechanisms in place to safeguard the rule of law than many other countries. Now, this is not necessarily a bad thing. In countries like Hungary and Poland, they had more formal mechanisms in place than we have in Norway, and it hasn't prevented Hungary or Poland from what they call the backsliding from the rule of law. So I'm not saying it's a bad thing, but so this is just a characterization that our system is very much based on trust. We have a system where public authorities have quite wide terms of reference. Our legislation is compared to legislation in many other countries, not very specific. It gives powers to the authorities, and we trust that the authorities apply these powers in a way that complies with the rule of law. We don't have much review of the authorities' use of these powers. Control is exercised mainly by corporate and political channels. In this way, not unlegal, but not clearly legal mechanisms. And we don't have a system, as they do in most of the European continental countries, a system of administrative courts, which means that very few of the decisions taken by public authorities are challenged in courts. This is, of course, a good thing. It saves us from a lot of bureaucracy. And when people trust each other and they trust the authorities, it saves us from a lot of expenses. It makes life perhaps easier and happier for many. But it's also a weakness. It's also a weakness. And maybe the high level of trust is the Achilles heel of our systems. We can go to another setting where the self-understanding of the rule of law was quite strong. And this is Germany before the Nazi takeover of power. The German legal tradition and the German rule of law tradition was actually the school book example for the development of the rule of law and development of legislation in Norway in the 19th century, when we started building our institutions after the independence from Denmark, and when we started building our legal institutions and our legal profession. It was to Germany that people went to learn about how to build a rule of law society. And we all know, I won't talk about what happened in Germany after 1933, you all are familiar with that. But you might not be familiar with this expression by Hans Frank, who at that time was the leader of the Nazi Legal Law Association in Germany. He was, before 1933, one of the main legal advisors to the leaders of the Nazi Party, to Adolf Hitler and the others. And after the takeover, he became the chairman of the Law Association of Germany. And then, after the invasion of Poland, he became the general governor of Poland, as you know, and he ended his life in Nuremberg after the war. But he once said, when asked to distinguish between the Nazi dictatorship and the Soviet dictatorship, he said that the main thing that distinguishes us, the Germans, from the barbarian Soviets is our independent judiciary. Now, this might seem strange when we all know what the German judiciary did during the Nazi time. But there is also a kernel of truth in this, because even though the judicial system was under the influence of the Nazis and under pressure by the newspapers and by the politicians, there was very little direct interference into the operation of the courts. And it was actually prohibited by Hitler himself for the party to address the courts in individual cases. And also there were some, not many, but some instances of judges ruling against the interests of the party and the interests of the state. But there were no harsh consequences on these judges. The judges were a privileged profession. Unlike any other profession, we know of no judge who was taken by the Gestapo or put in a concentration camp or who was criminally charged because of the way he exercised his position as a judge. This did not happen to any others, but they were immune, so to say, from this. So they had this self-understanding in Germany which prevented them from reconciling the position of a judge with direct interference from other organs of state. A judge under the interference of a politician was no judge. It was a contradiction in terms, so the Germans weren't able to think of this even. And I think this is a basic element then of it shows the strength of the habitus here, but it also shows, of course, the limits of it, because it didn't prevent Germany from turning into a totalitarian society with atrocious measures that the courts sanctioned or denied to interfere into. That happened under the auspices of the SS and the Gestapo. But how do we then reveal such weaknesses? It's easy, of course, afterwards to look at Germany and see what happened and to reveal it. But how can we reveal it in our own societies? Because after all, things are not by any measure that bad in our societies. Things are actually working quite well. But how do we then reveal the weaknesses? I think one way to reveal these weaknesses is to try to uncover the tacit assumptions and the way these tacit assumptions influence both the thinking in the legal order and the decisions taken. And I'll show this by a couple of examples. They're not very political, but I think they're illustrating in showing how this influences the legal mind. The first one is from a court case addressing a book written by the Norwegian journalist and author Åsne Seierstad. She wrote a book now about 20 years ago about the situation in Afghanistan after the first liberation of Afghanistan. And it was called The Bookseller in Kabul. It was translated into many languages, probably also into Icelandic. This book then became a great success. And it describes, she lived for quite some few months in an Afghan family in Kabul, where the host was a bookseller, and he had, as many Afghan men, he had several wives and children, of course, and Åsne Seierstad lived in this family, and the book describes then the inner workings of this family. And in a way that afterwards the bookseller and his family felt was quite invasive, and it's not always a sympathetic account that you get of this family, at least not seen with our Western eyes, and perhaps also not seen with Afghan eyes. So one of the wives of the bookseller sued Åsne Seierstad in a claim for damages for the invasion of privacy. And this came to the Norwegian courts, the court in Oslo. And the first thing that the courts in Norway had to decide was whether this case should be decided according to Norwegian law or Afghani law. Because, of course, this was a case that had relations to two countries, and it's always then a question of what law should you use from what jurisdiction, these choice of law questions are regulated by EU directives. So there are, but when it comes to freedom of speech and invasion of privacy rights, this is beyond the regulations that we have. So this had to be decided according then to unwritten law by the Norwegian courts. The basic sort of starting point for a court then, when deciding on such a question based on unwritten law, is to decide which country is the matter most specifically connected with. Is it most specifically connected with Norway? Then the answer is Norwegian law. Is it most specifically connected with Afghanistan? The answer is Afghani law. So this is sort of the basic rule. So we have to decide then whether this is a case that is connected with Norway or Afghanistan. Now, the interesting thing is I won't take you into the specifics of law, because I know you're not all lawyers here, and you're probably not so interested in the intricacies of choice of law. Look at the way the story about this case is constructed by the Supreme Court. And I will do this by by giving then the opening sentence of the judgment. A judgment in the Supreme Court in Norway is written as personal judgments in the name of each judge. So this is written then in the name of the judge who writes the first opinion, and it's a female judge, and she opens the judgment with the sentence that I have quoted here. It's of course in Norwegian, so I've translated it into English as my translation. But so the case opens, or the judgment opens like this: Åsne Seierstad, now Åsne Guldal Seierstad, published The Bookseller of Kabul in Norway 2002 with the publisher J.W. Kaplan's Forlag, now Kaplan Dam AS. Well, there's nothing very exceptional about this, of course. But let's go to the next sentence and see what she writes then. She writes, Seierstad lived with the Rice family in Kabul in Afghanistan in the spring of 2002. Her stay came about when she contacted the bookseller Rice and told him that she wanted to write a book about him and his family. Now this is not just a story, it's not just something that's taken place, it's a narrative. It narrates this story. And as a narrative, the author, in this case the judge, makes and has to make narrative choices. And we can see from just these two sentences some interesting choices that's been made in narrating this story. Now, one eye-springing choice is the way the judge here departs from the natural order of time. Because, of course, the story unfolded in reality the other way around. It didn't start with a book, it started with a stay. So this is what happened first, that she lived with the Rice family. But the judge has chosen then to interchange this, to start with something that happens later on in time, and then going back. Of course, this is often a choice made, you know, when you read novels and fiction. This is a very commonly used narrative choice. It's not that common in judgments. It's not that common in what we call sakprosa in Norwegian. But it can happen. But there are also some interesting consequences of this narrative choice. And we see this if we try to rewrite it. If we rewrite the narrative and we change the order, then it would look like this. Åsne Seierstad, now Åsne Guldal Seierstad, lived with the Rice family in Kabul in Afghanistan in the spring of 2002. Her stay came about when she contacted the bookseller Rice and told him that she wanted to write a book about him and his family. The same year she published The Bookseller of Kabul with the publisher and so on. Now what are the consequences of alternating the narrative in this way? Well, one thing that we do is that we change the whole narrative to become a story or a narrative about a visit. Whereas in the first case, starting with a book, it's a story about a book. Now, what relevance does this have to our legal question? Well, the book is published in Oslo, so it situates the whole case in Oslo. The visit takes place in Kabul, so it situates the whole story in Kabul. And when you remember that the question of the choice of law depends on where these events have their closest connection, well, this is quite significant, whether you situate it as a book from Norway or as a visit in Kabul. And we can even elaborate further. We can look at other choices that's been made. And another choice that's been made here, we have different actors in this story, of course. We have Åsne Seierstad, we have Mr. Rice, the bookseller, we have the wives of the bookseller and so on. And when a third party, it's a third party narrator, the judge here, is not part of these events, narrates these events, one has to choose a perspective. And here the judge has chosen the perspective of the author, of Åsne Seierstad. So we follow the events through Åsne Seierstad, but we could try to play with this and try to write it from the perspective of the bookseller, and then the story would go something like this. Shah Muhammad Rais, a bookseller in Kabul, Afghanistan, was approached by the journalist Åsne Seierstad, who asked if she could stay with his family and write a book about them. She lived with him and his family for the spring of 2002. Later that year, the visitor published The Bookseller of Kabul in Norway with the publisher J.V. Kappelstam Forlagna Kappelstam AS. Okay, so we see from this the consequences are that the story is even further situated in Kabul. Now, the nationality of the author of the book becomes quite insignificant. The book could have been written by, was written by a Norwegian author, but it could have been written by a German author, an Icelandic author, or whatever. That's not so significant to the story as it now unfolds, seen from the perspective of the bookseller. Now, this the important question is then not, of course, that you have to make narrative choices, because you can't avoid making narrative choices when you construct a narrative. So this is unavoidable. But the interesting question is, of course, why the different narrative choices are made, and the consequences of this for how you see the legal question. In this case, I think that there was a cultural narrative in Norway which was so embedded in Norwegian society that it was impossible for the judges to narrate it in a different way from what they did. Because we all knew about this. Also, Seierstad was our national hero. She was young and brilliant and brave and beautiful, and she went out to the war zone and everything, and this book had been highly acclaimed, and it's not that often that a Norwegian book is published in 40 or so countries and becomes an international bestseller. So the story about the book in Åsne Seierstad was sort of a key story in the Norwegian doxa. So the bookseller, in some way, didn't stand a chance when he said that he wanted to apply Afghani law. In addition comes, of course, that Afghani law was very difficult to determine for the judges. And I think also that many of the judges and many in the Norwegian public were quite suspicious as to what would Afghani law have to tell us about freedom of speech. That might be a prejudice, but at least I think that's a sentiment. So which story is real? They're all real, but they have different consequences. Another example is an example from some years ago about a Kurdic freedom fighter, or part of the Kurdic movement in Iraq, who came to Norway with his family as part of the UN quota system of refugees. And after 9/11, it was revealed that he was on the terror list of the Americans. When the Norwegian authorities investigated them, they found out that he had been a militant leader of one of the militant groups in the Kurdish areas of Iraq. He had been leading a group that had performed terrorist acts, bombings and other things against public buildings, both of the Iraq and of the PKK, the main Kurdic movement. And so they wanted to expel him from Norway. This was then brought to the courts, and one of the main issue then was whether he was a threat to national security in Norway, whether his presence in Norway was a threat. And if it was a threat to national security, then the authorities had the power to expel him. The court then, in this case also came up to the Supreme Court, was over controlling then the discretion exercised by the authorities on as to whether he was a threat to national security or not. Now, the interesting thing is that the actual themes that were part of the reasoning of the court and part of the arguments before the court never went directly to whether he was a threat or not, or whether it was probable that he would be planning or performing acts that were threatening to Norwegian security. The themes of the arguments went to establish two things: whether he had a link to this terrorist movement in North Iraq, or whether he had broken these links. And the other topic was whether there were any connections with this group in Iraq and Al-Qaeda and bin Laden, who had been behind the 9/11 attacks. These were argued, and the Supreme Court then established that yes, he had maintained ties with his movement in Iraq, and yes, there were some connection between the Iraqi movement and Al-Qaeda. And so then the court concluded that yes, he is a threat to national security. But what was never a topic of the case was how these two things, his connection with this movement in northern Iraq and the connection between this movement and bin Laden, how this was a danger to Norwegian security. This was just taken for granted, that since he had these connections, he was a danger to Norwegian society. And this was taken for granted by the courts. There was no argument about it, though it wasn't problematized. And it was taken for granted by the Norwegian public. There was no criticism of this court ruling after it ruled that he could be expelled. One question that I think deserves to be asked is, why was this taken for granted? Why was it not challenged when it wasn't even a topic of the deliberations of the courts? Well, I think an explanation to this is another part of the doxa, which is not specifically legal, but it is the metaphor of something which is close, has an effect on us, and has a stronger effect on us, and something which is more remote. It's a very common way of thinking. I mean, we say that of a person that he had the air of the king, which meaning that he was near to the king, and therefore, of course, he influenced it. So the real person of power is the advisor and not the king himself. It's a way of thinking that we just take for granted. And in this case, there was a link established between Mullah Krekar, who was his name, and bin Laden, who we all felt was, or knew was really dangerous because he had blown up the World Trade Center. And because of this closeness then, there is an effect on our national security. So this metaphor, in this case, operated so strongly that nobody saw the need to actually go into an investigation or problematization of the possible effects. So we were all threatened then. This was what we sort of saw in front of us as long as Mullah Krekar was allowed to stay in Norway. Of course, I should have substituted these pictures with some buildings in Oslo, but I'm not clever enough on Photoshop to do that. But I saw recently now that I could use maybe artificial intelligence, and so next time I might have some different buildings here, but you get the meaning anyway. So this is another example then of how these things that we just take for granted influence the way we take legal decisions. I'm not saying that they determine them. Of course, it's possible to rise oneself out of this. In the case of Åsne Seierstad, it would have been possible, perhaps, for a clever lawyer on the side of the bookseller to break with this cultural story, to tell another story. But it didn't happen. But in many court cases, of course, this is what clever strategic advocates do. They battle over the way to tell the story. and not so much on the legal issues, because once you have established a story in the mind of the judge, the case is half won. And you still have to go through the legal exercise, of course. And the same with this lawyer here could have broken with this metaphor. But this means then that in the tacit assumptions and in the doxa, this is where the dangers lie to the rule of law. This is how, I think, the development could take place in Nazi Germany, despite the maintenance of a high number of legal regulations, and in spite of maintaining, so to say, the formal rule of law within the legal system. There was a German lawyer of Jewish origin, Ernst Frenkel was his name, who was allowed to practice law in Germany after 1933 because he was a hero of World War I. And Jews who had fought in World War I were exempt initially from the persecution. So he was allowed to practice until 1938, when the repression also hit the former war heroes. He then escaped to the United States, and he took up a new career as a political scientist. And he wrote then his thesis, The Dual Law, in the United States in 1941 or 42. I think it was 41 it was published. Based then on his experiences from the inside of the German legal system. And he said that what you could see in Germany developing was, on the one hand, a continuation of the rule of law in the courts. The courts were operating more or less as normal, with legal arguments. They were applying the laws. Of course, many of the laws changed, but not all the laws changed. But at the same time, the atrocities of the political persecution and the racial persecution developed despite of this. And he said this is actually a dual state. There's a state outside the legal state, which is expanding. This we know from all societies, of course, that we have areas that operate outside the scope of law. But what is special about the dual state that Ernst Frenkel described was, on the one hand, the vastness, the expansion of it, what he called the prerogative state, but in addition, the shift of the authority to decide on the matter of jurisdiction between the prerogative state and the normative state. In our societies, basically, the courts decide on whether they can intervene into the more expedient measures taken by the government. But what happened in Germany was that this shifted. So it was the prerogative state, it was the SS who had the final say. So if there was a battle over jurisdiction, the jurisdiction of the courts and the jurisdiction of the law was limited by what he then said was the prerogative state. So this means that one could have both a continuity in Germany, with a continuity of the operation of the legal system, and a total break, a revolutionary break, because the prerogative state was given the final say. How then does this happen in our societies? Can we experience the same? We have the same. We have the same situation. We have a rule of law society, but we have all these basic assumptions, everything we take for granted, that the operation of the system depends on. Because one of the things that was taken for granted by the Germans was the need for the German people to protect itself against the Jews. This wasn't just the Nazis, this was taken for granted by large proportions of society. And when you put this as a tacit assumption into the operation of the courts, you get the development that you got, where Jews were deprived of their basic rights within marriages, within labor contracts, within bankruptcies and whatever. through the application of the old laws by the courts. This was not done by Hitler and his men. It was not done by legislation. It was done by judges applying the law under the assumption that the German people needs to protect itself against the dangerous Jewish enemy. What then are the situation here? I think that we should learn something from what we've been going through in the past years during the pandemic. And I'm not saying that the pandemic turned our societies into a Nazi state. I'm not saying that it turned our societies into a dual state. But it showed very clearly the weaknesses in our society in a situation where there is a defined threat, an emergency to the state. And we all remember how the authorities, with the support of a vast majority of the population, defined the pandemic as a mortal threat to our society, which necessitated then that the government use emergency powers. And what were, so to say, the elements of the emergency powers in the pandemic? Well, I can only speak with detailed knowledge about Norway. I haven't followed the Icelandic development so closely. But in Norway we had the elements of, so to say, the dual state within the hygiene measures sector, and even going beyond that. During the first couple of weeks of the pandemic in Norway, the government suddenly, without any consultation or without any publicity, announced a bill to Parliament where the government should be given more or less unregulated powers to legislate what was necessary in face of the pandemic. This was an emergency power. That was, the government initially proposed that it should have these powers for 2 years. There were some consultations during the week with the leaders of the major political parties in Parliament, and they agreed to this legislation, but they brought the time from 2 years down to 6 months, and this was then the bill as it was proposed on a Thursday by the government, and their intention was then that the Parliament should pass the bill as a law during the beginning of the next week, so over the weekend. This created an outcry in the public in Norway. So there was some discussion, and the political parties in Parliament, they changed their positions, some of them at least, during the weekend. And the result was then that the act was passed, but with a limitation of the powers of the government. So it was not an unlimited power any longer, but it was limited to specified areas. And the time that the powers should extend for was reduced to 1 month. So instead of 2 years as the government initially wanted, it was 1 month. But it is quite thought-provoking that the government even could propose such a measure in such a way without any prior consultation, and with secret consultations then with only some of the parties in Parliament and the leaders. We also had we have in our Pandemic Prevention or Contagious Disease Act, we have quite unregulated powers to give health measures and restrictions, but even these were expanded, and they are built on our Emergency Powers Act from 1950, which is to deal with war and warlike situations, and this act has a supervisory mechanism where the parliament then can exercise supervision. And if the government passes a measure, then if they want to prolong it longer than 6 months, it has to be proposed as a bill to the parliament, and the parliament has then to decide on it as a law. And this was the same system that was incorporated into the Disease Prevention Act, but the government circumvented this and established a practice where the bills were not proposed to Parliament, but Parliament only had to be asked to give a more general power to enact the type of regulations, which is of course a very wide or very harsh weakening of the democratic control. And the regulations passed by the government were passed without any public consultation and so on. So there was also deficiencies in the cooperation from civil society. So the powers then were quite unregulated. The democratic system to exercise control was more or less abolished. And there were, of course, measures regulating and limited individual rights to a great extent. Mostly rights of free movement, but also rights of family rights, the right of members of families to visit each other, the right of family members living abroad to they couldn't visit their family members for a matter of more than a year. There was also an issue of assembly rights and freedom of speech, religious rights. Churches were more or less closed. Freedom of speech was actually preserved not by the authorities but by the police, because the police refused to apply the pandemic restrictions on public demonstrations at an instance, and then the government then gave in and did not apply these to the freedom of speech and public demonstrations. So what does this say then? Well, it shows us that in certain instances, under specific circumstances, the government is prepared to abolish many of these mechanisms that we regard as essential to the rule of law. With the consent of a majority of the people. And that is, of course, the situations that are dangerous, is when the majority of the people see the situation as threatening. It's the same as during the Cold War, where the communist threat was seen as threatening by a majority, which led to then an infringement of civil rights, going much further than just to the communist members of the Communist Party, but there was a political surveillance and limitation of assembly rights and political rights. So we must not be self-complacent and think that just because we have the rule of law and we have the formal systems in place, and just because we have a long tradition of a rule of law and a self-understanding, that we are, to use the words of the pandemic, vaccinated against a development which is a development that we very much would not like to see. I think I will stop there so that there's some time for questions or comments. So thank you.
Det som truer den akademiske friheten først og fremst manglende forståelse av hva vitenskapelig virksomhet går ut på. Mange blander det sammen med samfunnsnytte, men vitenskapelig virksomhet verdifull for samfunnet på helt andre måter også. Men den må få følge sin egen art, både måten vi organiserer den på, og måten den enkelte forsker utøver sin virksomhet på. Og når samfunnet ikke forstår det, da blir det lett til at man kan underlegge universiteter og høyskoler og andre virksomheter rammebetingelser som truer den akademiske frihet.
Yeah.